I'm going to call the May 15th special meeting of the Bucksport Planning Board in order. Roll call.
Stephen Bishop.
Present.
Brian McDonald.
Here.
David Grant's absent. Steve Flight is absent. Edward Belcher.
Here.
George Hansen.
Here.
Jay DeRost.
Here.
Planning Board workshop. Basic duties and responsibilities.
Good evening to you all. I'm Diane O'Connell. I'm an attorney in Ellsworth. Until recently, I lived in Bucksport for almost 14 years. And I see that David's not here tonight, but he was the first person I met when I came to Bucksport. Showed me a house, which I didn't buy, but I've known David for a long time. And I know he's been on the planning board on and off for a long time. I know by looking at this here, probably some of you have been on the planning board for some time, on and off. So I hope I'm not preaching to the choir, and been here for a while. And as you know, it can be a difficult job. I work in Ellsworth. My law partner, Jim Patterson, used to be the attorney for the town of Bucksport sort of during the 80s and 90s, prior to my time. And I've worked for the town of Bucksport from time to time as well. Worked with Jeff on a few things, and I've come and given a few seminars here. In my law practice, I do represent a number of municipalities. I also represent applicants before various boards, and I represent boards in their capacity when they're sitting and making decisions, planning boards, more often the Board of Appeals. And it's not an easy job. I think I struggle with some of the rules and some of the issues that you have to deal with. And from my experience, I want to focus on some of the things that I think are most important in your role as planning board members. And I'm happy for you to ask questions as well if you've got things that you want me to address. I can't promise I'll know the answer, but at least I'll write it down and I can get back to you, with an answer. Having said that, please don't ask me about a pending application or anything too specific, because I really can't comment on something specifically that's before you. In general terms, certainly can answer questions on procedure and that type of thing. So what I'm going to start with tonight is really something that's key, and that's kind of runs through everything you do, and that's the right to know law, freedom of access to information, and also the right of the public to be able to come to meetings and to know what's going on. As you know, when you're meeting, you have to notice it to the public so that they can attend and that they can partake, or at least come and watch what's going on. Not all meetings require that you give the public the opportunity to speak, but they do have the opportunity to attend meetings that you have, and that usually includes subcommittee meetings if you're going to make any decisions about anything as well. So it's important that the public get notice that part of that is when you are communicating as a board outside of a public meeting. It's very important that, I know today with email it's very easy to send an email around. Sometimes you might express an opinion on the subject matter, so at all possible you need to avoid doing that. So any communications outside your actual meeting should be limited to agenda items, procedural, setting a meeting time, finding out who could attend a meeting, those kinds of things. That's certainly allowed, but anything to do with an application that's pending or anything substantive, like polling each other, what are you going to vote, who's going to vote on what, that's certainly not allowed. So part of that right to know law extends over to times when you might want to do a drive-by of a site. You can certainly have a public site visit. If you're going to do one, you would notice it just like you would a public meeting, so that all the public have a right to attend as well. Sometimes a person one of the board members might not be able to attend a site visit, and they may want to just go on their own. You can actually do that. I think the things you need to be careful about is that you're not you're not communicating with the applicant while you're there, and that when you come back to the meeting, you can put it on record that you were there and what you saw, what you did when you were there. The other thing, when you do have a site visit, it's always good to try to see that your secretary is there, who's ever the designated secretary. If that's you. Oh, someone's missing. They should take notes generally if there's going to be any kind of questions. If there's no way to record it, either with the secretary being there. You should try and limit the type of discussions that you have, because it is a public meeting, and you should be able to record what's going on. It's also important when you're back here, at the next meeting you have on the application, to put it in the record of what you did at the site visit and that type of thing. Some of the common violations that happen is that people might meet outside of a meeting. If there's more than 3 of you there, you constitute, I think that's, well, how many is on the board? Seven. Right, so I guess if there was 4 of you. But in any event, you shouldn't have discussions about an application that hasn't been decided on, whether it's amongst yourselves, whether it's with a person. You may have had the experience where someone comes up and says, oh, I read in the paper that there's something going on, what do you think about it? And obviously you need to avoid having those kinds of discussions. It's easier to say that, I think, than put it into practice, because we all live in a small community. That's really hard sometimes, to avoid those kinds of incidences. But it's very important to try and keep any discussion about a pending application, to yourself, and don't have that discussion outside of this forum.
Diane, I've got a question back when you were talking about site visits. If the planning board schedules a site visit and the applicant would rather not have the public on their property because of liability issues, how can you handle that?
If the landowner and the municipality are covered, because it's a municipal public hearing, they are covered under the Municipal Tort Claims Act. So that could give the landowner some comfort. However, if it's a type of commercial facility that might be a little inherently dangerous, then I think there needs to be some sort of management. You can't just say to the public they can't come, but you need to manage it in a way that you usually would with a public safety issue. And maybe even just kind of limit how much of the site visit that you do.
Can the property owner ask the public to sign waivers?
Yeah, absolutely. I don't see that being an issue, that they would have to do that. But generally they're covered. It's a public meeting and they get the same protections as the municipality would, provided they don't have anything inherently negligently dangerous on your property.
Well, they did a site visit several years ago at a gravel pit. The applicant was proposing to expand and mine some stone, and he allowed the planning board members to go in, but not the public that was there. I think because he was concerned about liability.
Right. Yeah.
I think he supplied us with hard hats and stuff too for that visit.
Yeah. But if that should happen on site, where just out of nowhere, the landowner says you as public can't come in, should the planning board stop their site visit at that point?
I think they should. Because the whole point of the right to know law is to be open and allow the public to view what's going on in governmental entities. And so when they're excluded from that, it's violating the right to know law. So you have to decide you're either not going to have a site visit or you're going to reconvene it under more controlled circumstances, and you would have a public safety plan if it's an inherently dangerous facility. You could also do, perhaps have have a member go and do a video of the site and come back and have it in the public hearing. But no, I don't agree that you can exclude the public.
One thing I've also seen happen over the course, I think the board has done probably half a dozen site visits since I've been here, and quite frequently they'll go onto the property and then they'll break up into small groups, and you get a couple going over here and looking at something, and 3 or 4 going that way. It's hard to discourage that, but really you should keep staying together, right, so everybody can hear what's being said.
I think it's important to realize it is still part of your public hearing, and sometimes you can be asking questions which are evidentiary. That's why it's important to try. I mean, like I said, a lot of this, it's easy to say and hard to put into practice, especially when you're doing things on the fly. But you should try to record. I mean, there's certain things where you're just saying, oh, well, the person's showing you around and they're basically saying, here's the pit and here's this and here's that. But if you're asking, specific questions that are really going to impact maybe on your decision, then it's best for everyone to be together hearing those, and generally someone recording it, which is not always easy when you're out on a site visit. Yeah. So, these are the rules. Sometimes they're hard to put into practice. But generally, whoever, you're the chairperson, correct? So it's still your job to kind of manage the site visit, because it is still a public hearing, and secretary to try and record it. And then when you do come back here, you can summarise, what you did and what went on, and that type of thing. Yeah.
So in the event there was any resistance from the applicant about letting the public on their property for a site visit, it would be best to just narrow the scope of the purpose of the site visit in order to determine what we needed for information.
Yes, I mean, I think a site visit can be helpful, but it's not always necessary. If the board feels like if the applicant requests it, you still don't have to do one. But if the applicant requests it, I don't think they could then turn around and say the public can't come on. Okay. If the board members say they'd like to and the property owner says no, well, you can't go on. But I don't think they can let the board on and then not the public.
Okay.
You either don't have one, or you manage it in a way that the public can come in.
Okay.
Even if you're sort of going to do it, I can understand a gravel pit, can have some dangerous aspects, but I mean, most people are know to stay away from the edge of the pit, so you just use common sense. I think I think sometimes if they're resistant, they're going to just move because they don't want the opponents to be there. Is more the thing, and that's the whole purpose of having open public hearings. So kind of tied into the right to know law is conflicts of interest and bias. More so the bias side of it, but I'm going to start with the conflicts of interest. There is a statutory test, and in fact your planning board, you do have your own rules of procedure, and then you have Article 5 in the Town Charter, Chapter 4, and you have a section on conflict of interest and bias, and it's very similar to what's set out in the statutes regarding that. And I certainly recommend that for those of you that don't remember what's in your documents, that you read them from time to time, just to reacquaint yourself with some of the rules, because if you're like me, you don't retain information well, it's helpful. But essentially there's a statutory test which would disqualify a board member from sitting for having a conflict of interest. It's a two-pronged test. One of them is if you're an officer, director, partner, associate, employee, or a stockholder of the applicant, and you have at least a 10% ownership interest. Just having one but not the other doesn't technically disqualify you. So then it's more of a judgment call on whether you feel like you should recuse yourself anyway. And then apart from the statutory test, there's different case law. Case law is when the Maine Supreme Court makes rulings on cases and kind of sets a decision that everybody else has to follow. And their tests are often just words that are sometimes hard to really know what they mean. But they have a test that says whether the town official, in this case a board member, by reason of his interest, is placed in a situation of temptation to serve his own personal interest to the prejudice of the interest of the applicant. So I don't know, I mean, again, it's a common sense thing. If you think that you really can't make a unbiased decision or a decision because you're interested in the outcome, for example, if it's an application for a fish farm and you see that you can provide a raw product or provide something to it, and you're like, yay, let's do this, and maybe you've got a conflict of interest, those sorts of things.
But I don't figure I do.
Oh, I wasn't looking at you.
No, but
I was just pulling that one
Okay,
out of the air.
we approved last month a facility in an industrial park.
Right.
Now, I work at home, and I do estimates on reinforcing steel. So I ended up getting the plans from a contractor that proposing to build that unit. So I did an estimate of the company I work for. But I mean, for me, I don't know whether, when I do an estimate, I do not know when I send the estimate to them that the contractor uses us to buy the product. And the other point is, I'm salaried, so there's no
Right, so
incentive.
the outcome of the application, it doesn't depend on whether you get paid or not for doing your estimate.
No.
You get paid regardless. So yeah, so so the thing about conflicts is it's always best to come in and just say, before you start, you say, well, I did this, and what you just said, and just get it out there, and then ask, does anyone object? And usually people say, well, no, that's fine. But it's better to get those things out on the record first, so that later someone doesn't complain, about it. Being in a small town, there's often some degree of connection if you go back, 7 degrees of whatever to someone. So it's good just to mention that, they were a former client, but you have no longer have a relationship, or you're a contractor and you built a house for them 5 years ago, but that's finished and this is something different. We can just mention it.
Was that free lobster for life? Was that getting?
That had nothing to do with it. No.
I don't know the applicant.
We have a checklist of what the board does when they conduct a site plan review, and one of the things that they do is determine if there is a conflict of interest or bias.
Yes. Yeah.
So they do that every time.
Yeah, I saw that you were going through, which is great, but it's not. People don't always think about what could be a conflict. So it's good just to mention it. Sometimes it's not legally a conflict. Sometimes it's just what looks bad in the public eye. There is a section in the municipal statutes that says every municipal official shall attempt to avoid the appearance of a conflict of interest by disclosures or abstention. So, it just kind of, I don't think you should make that your overriding obligation, because otherwise you'd be, conflicted out all the time. But keep in mind, if you are kind of undecided, and if it's a controversial issue, sometimes it's better just to step down so long as there's enough members to make up a quorum.
What is the most appropriate time to do that?
Right at the beginning.
At the beginning of the meeting?
Yeah.
Okay.
Before anything substantive begins, usually there's the whole procedure where you're going through those kinds of things, and the standing, the jurisdiction, before you even get into the meat of the application, and then that's when conflict of interest and bias will come in. Bias is slightly different. They're really related, and they should be dealt with the same way. There is a statutory provision that relates to bias in the Title I, Section 71(6). It says that a board member must disqualify him or herself in a situation that requires the board member to be disinterested or indifferent, and the board member must make a quasi-judicial decision, which involves a person whom the board member is related by blood or marriage within the 6th degree, So, so there is, I can leave this with Jeff. I do have a little outline that shows what a 6th degree relationship is. So that's a statutory requirement that if you are related to that degree, you've got to step down. Then there is just the common law kind of bias where it's very, the case law on it is airy-fairy at best. It's not always easy to determine, but bias is more to do with your state of mind, not so much whether you know someone or not. And it's very hard to prove. Like, again, it's more of a public perception. It's very hard for someone to, if they got denied and they feel like it was because someone was biased against them and they appeal it, it's really hard to prove it because, there could be a number of other reasons why it was denied. Even if somebody kind of doesn't really like you, if you didn't meet the standards, you didn't meet the standards. So sometimes, again, it's a public perception thing. If somebody's known to have, constantly writes letters to the newspaper or is very vocal and then, says things like, there's no way I'd ever approve a gravel pit over my dead body, and then they get appointed to the planning board or they, that's going to be, and they deny a gravel permit, that's kind of going to be a good case for bias, but it's never that clear cut. So again, it's up to, if you feel like you can't make a decision because of the way you feel about not so much the person, but the application, if it's for something that you just really don't think the town needs, even though the ordinance allows it, then you should probably just say, I'm going to step down from this one. And you can just say, I don't feel like I can be unbiased, and that's fine. That's all you need to say. Now, sometimes members of the public or one of the applicants or an opponent to the applicant might say, I think so-and-so is biased. They might sort of make an allegation that one of the planning board members are biased, and if that's the case, then that person should be given the chance to address that, respond to it, and then the board members have to take a vote on whether or not they think that person should recuse themselves or not. Once that vote's taken, that's the end of it. And if you do vote that person should not partake in the decision making, then they have to just go sit in the public audience or go home. That's how you deal with that.
Is it sufficient just for that member to say, I'm absolutely not biased on this application,
Yes.
to satisfy the board?
Well, it's up to the board. I mean, the person can say, it's true, I have a business that that's competing, but I honestly believe that I can make this decision based on what the ordinance criteria says and what the evidence is presented. And the other board members, because you might know this person, and you say, yes, absolutely, I 100% agree that he will he can do that. And you can just vote not to have her or him step down. So to be honest, I don't think I've come across a situation. Oh yes, I have. There's only been one time where the board members, the person did not want to recuse themselves, and the other board members voted that he should. And he stormed off.
And that should be done by vote, not straw poll or consensus. It should be done by vote.
I've just done by vote unless your rules say otherwise, but I think your rules here say that it should be just by vote. When a question of an alleged conflict or bias of any member is raised, that member must decide by majority vote of the other board members. So it's right in your rules.
Okay.
Sounds like a good way to do it.
Yeah. So the bias kind of can get back into the whole right to know law, because sometimes the bias will arise where a planning board member might start their own investigation into something. Either they have access to like building plans, or they're doing like site visits, or nighttime reconnaissance or something, and that would really go beyond what their role as a planning board member is. I mean, you can rely on your own experience and knowledge, but you shouldn't go out looking for evidence about the application yourself, because that would sort of lead one to suspect that you're biased either way if you're out there trying to find information on the application.
Were you even allowed to do that, Jeff?
Do what?
She said, something's coming up, you just step out on your own to do your investigation or whatever you want to call it. I mean, can we even do that?
You're not supposed to do that.
Isn't our business all supposed to be conducted right?
That's the point.
Yeah.
Yes, but people do different things. You know, sometimes you may feel that you could go find out some information. So, you know, sometimes you've got a nagging question, and instead of waiting for the public hearing to ask the question, you go and do several drive-bys of the house. I mean, if somebody sees you constantly driving by their house, they're going to say, well, you know, he's checking out my property. I think, you know, he's not impartial. So, you know, it's just...
Well, in this day and age, it's such a bias, it's such a fine line. It
is.
As you say, someone could see you driving by back and forth twice and say, well, he's conducting business outside of the realm of the planning board. Mm-hmm. And he's really...
Well, you know, as I said, it's extremely hard for an applicant to prove bias, but everything that you do, if it's a hotly contested, especially if it's a contested type of issue, is going to be scrutinized by...
But sometimes it could be hard to disprove bias as much as it is to prove it.
Exactly.
So it's a fine line you have to walk. It really is.
I mean, it's part of your responsibility as planning board members, because we all have our own opinions, whether or not part of the process is that someone who lives in the town and applies for something, they need to have some certainty of, you know, what are the rules, and, you know, is there consistency with the decision making, and be confident that if they follow the rules that are set out in the ordinance, that their application is going to be approved, regardless of what the planning board members personally think of the merits of the application. If the ordinance allows it and they've come and they've met the burden of the criteria, that's when you have to put your own feelings aside and decide whether they've met their burden of proof and prove the criteria that the ordinance specifies, even if you don't like the ordinance. I mean, sometimes people might be motivated to join the planning board because they don't like what's on the town books as far as the ordinance goes. And that's fine if you do that and try to change it within the realm of, you know, ordinance amendment, but you can't change it sitting here making decisions, because you have to, you know, if somebody's met the criteria, you have to grant them, you know, you have to give them the application, you have to grant it. So that's and it kind of dovetails into the whole bias, because you have to set aside your biases sometimes.
What happens, Diane, when an applicant presents an application that, say, for example, says that the lot I'm proposing to develop is high and dry, and a board member has personal knowledge otherwise, it's full of wetlands, for example?
Yeah.
How can they use that information?
They can use. You're allowed to give. If you have personal knowledge, you're allowed to put that in the record. You know, you could say, well, actually, I know that property. You know, I grew up as a boy hunting there, and I can tell you it's as wet can be. Just because you have that personal knowledge and experience, you know, you can do that, and then that's, you know, it's a good time to go for a site visit. Maybe, you know, if you feel like that there is.
Present a factual situation.
Yeah, because, you know, you will have a lot of experience in different ways in different areas, I'm sure. So you're going to have a lot of personal knowledge that's going to maybe not so much affect, but you might know something about the application, and that's okay. It's okay. And you would just say that right in the record. You would say, well, I have personal knowledge of this. I don't think that's a bias thing, because of the fact that you know there's wetlands there. That's just a fact that you know. So that something like that would be perfectly fine, as long as you state it in the record. You know, because sort of brings us to another thing with the right to know law is when you are making a decision and you get to the point, it does say that you have to do findings of facts and conclusions of law sufficient to appraise the applicant and the parties of the reasons for your decision, either to grant it or deny it. So part of that decision-making process, if you say, I know for a fact that it's wet because I grew up in the area and we used to go there all the time, and if part of the application was that it couldn't be wet, and you deny it on that ground, it needs to be in the record why you denied it and the fact that you had that personal knowledge. So the decision-making and writing process is a difficult one for many boards as far as articulating the reasons, the findings, and the conclusions. How do you usually manage that when you're meeting and you've made a decision? Do you collectively do it, or do you sort of discuss it, make the decision, and then assign it to one member to write up the decision and then come back and approve it? How do you usually handle that?
They have a checklist they go through, and they review the development standards in our land use ordinance are grouped based on the type of standard it is. So they go through each group of standards and determine, first of all, which ones are applicable. And then they determine if the applicant has met the standards that are applicable. They go through all those standards, then they go back and do findings on each group of standards that they find to be applicable.
Okay.
And if they make a positive finding on every one that they found to be applicable, the application is deemed to be approved automatically. There's no final vote taken. If they made a positive finding on every applicable standard, the application is automatically approved.
So generally there should be a final, even though you've gone through and there's enough positives, you should make a general one that...
There's a statement made. There's a statement by the chair that, in effect, states for the record that they've made a positive finding on all applicable standards, and therefore the application has been approved.
Yeah. My recommendation is to make that final motion and say, I move that based on, us finding a positive standard, that we move to accept and approve the application and kind of make that final determination.
I think the reason why that they do it that way is because of the potential, the possibility of having planning board members who oppose the standard or two to also oppose the final approval, even though the majority of the standards may have been approved. Or in fact, all of them were approved, but not unanimously.
Yes, and if they did that, of course, you'd be appealed and it would be overturned. Because, you can't do that.
Why is it so important to have that final motion?
It's because each criteria is just a criteria on its own. So it's not the motion to actually approve or deny it has to be made at the end. That's, my recommendation to do that. It's just like one final step.
Just adds 2 minutes to the...
Yeah, it's one more step.
Yeah.
The final step.
Yeah.
And, because sometimes there's, you go through the criteria, there might be, it's not always a unanimous vote, even though each one is voted on and passes. So, for example, you should always, it's good practice to write down if it was a 3 to 4 vote, even though it was a positive vote, you should sort of know who approved it and who didn't. And sometimes the people that didn't approve it, like a certain criteria, at the very end may vote to approve the overall granting, which is fine as well.
But if they don't, there's a possibility the application could be denied, even though they made positive findings on all the standards that were applicable.
Correct. If they made positive findings on all the standards, but that's up to the chair to just to manage that and say, here we are. We've made positive findings on all of these, and based on the positive findings and that the applicants met all the criteria in our standard, I make the motion that we grant the application. Somebody's going to second it, and what you might find then is that everybody, the other people that said no on those certain things are going to say yes to that because they know that they've already
The majority
has been met.
Yeah.
I
I think
I would
if-
find it highly unlikely that you would have people to like approve everything and then, you know, it's more of just a stamp, but it's kind of a formality because there's been, each one is a separate criteria that you could win or lose on. So you kind of have to meet them all and then you get, you know, the final.
if they're all met, I don't think you would have enough opposed to deny.
They would all have to be met unanimously, right?
As we
No,
go
I mean,
in,
we could vote 5-2 that this was met and that was met, or 4-3. But if you vote 2, 4, and 5 against, you know, then it wasn't, you know, we found that it wasn't met. But if everything has got a positive vote, I think the end would have to have a positive vote as well.
but I think part of the way around this is when somebody has an objection, something will move over to a condition, make a condition to satisfy something that somebody has a concern about. And if it goes into conditions, then, and the conditions are acceptable to the applicant, then I think that the negative vote over here becomes moot because it's carried over and put in as a condition to the approval. Know what I mean?
If you have 4 different members who each individually voted against the standard, but the standard still was, you know, there still was a majority vote in favor of the standard.
You couldn't have a majority vote though, could you, with 4
No, I'm
against,
talking
because it's only 7?
One member, four
member.
members voted against 4 different standards, but the majority still ruled.
Yeah.
You could-
Those 4 members could, in the end, vote against the application because they were opposed to, you know, their individual standard they didn't like.
Correct.
That's quite possible, yes.
But wouldn't that kind of tread kind of close to being biased?
I think the thing
wouldn't
is you
one
need to-
issue throw the whole thing off for
You need to
somebody?
counsel your board members that it's a procedural thing more than anything else, that you need to, you know, you need to have that final motion to show the outcome of the application, and it's not a chance to deny an application that you've effectively approved. But from the case law I've read and the different literature on it, they do, you know, the consensus is that you should have that final motion approving it when it has effectively been approved by going through the different criteria.
And obviously,
So
something like that
that-
would be a holdup because of lack of information or one particular thing. So essentially, would it be smart to just hit the pause button and say, let's table this pending further information?
You can always do, you do have inherent authority just to table a matter, whether you want to get legal advice on it, what something means, or you want more information from the applicant, or if you want to explore some conditions, because you always have the inherent jurisdiction to place conditions on an application as well, as long as they don't have the practical effect of making it impossible to
Right.
do what they want to do.
As opposed to making a mess or having a mess, just table it pending further information before things get out of control.
Just transfer the mess to the next meeting.
Right.
Yeah.
Hopefully somebody will learn something in the process.
So the review process is actually, it's in our ordinance, and it says that an application for which a positive finding has been made for all applicable Section 15 performance criteria is deemed approved by the planning board. An application for which a positive finding has not been made for any applicable Section 15 performance criteria is deemed denied by the planning board.
Yeah. But I still think you should make that, and, you know, the chair can say, you know, in our ordinance it's deemed approved. But I still think you should make that final motion that we, you know.
For some reason, I'm thinking that this is in here because of something that was put forward by MMA. I'll have to look at that again.
Yeah. Yeah. That's just my opinion,
Yeah.
is that each criteria is different, and sometimes too, you know, you're going through and saying, well, that's not applicable. You know, that criteria is not applicable, and this criteria is, you know, so it's not like there's always a standard set that is relevant to every single, you know, thing. So, and it's important when you go through and you vote and say, yes, we approve that criteria, or they've met that criteria, like for a site plan, what is it, drainage or something, stormwater runoff. You should then say why you made that decision. That's the important thing to learn to kind of train yourself to think about, because if anything gets appealed, you need to sort of have the findings of fact that back up the decision. For example, you can say, the developer or the applicant submitted, whatever reports showing what was going to, stormwater runoff, and it showed that there was going to be no issue. There was an expert giving evidence on that, and therefore we find that they've met that criteria. So try and point to something in the evidence to back up your decision. And it goes both ways. If you don't think they met a criteria, you can just say, well, they didn't present any evidence to show that it didn't meet their burden, there was no evidence. Something along those lines. Kind of want to avoid the situation where somebody's appealing it, goes through the Board of Appeals and then to the Superior Court, and the Superior Court says, well, there's no reasons here why you made your decision, so I'm going to send it back to the Planning Board so they can articulate their findings, and then it goes all the way back. I've been in that situation where, 2 years later, it finally kind of rolls through. So your, like I said, you do have some set procedure that sort of sets your administrative running of the planning board, and some of the things that you have to go through. There are certain applications that come before you that you have more trouble with over other types of applications.
Recently?
The quick answer is applications that aren't thoroughly prepared.
Right.
Those are very difficult to deal
Yeah.
with.
So a lot of it is just the it's almost like before they meet even the application standards, you're sending them off like 2 or 3 times.
I think Jeff might be.
Jeff does that first.
Yeah,
You vet it.
I don't think we
He's
do.
the first applicant contact,
Yeah.
and he has a checklist.
Yeah. So you don't set it for hearing until they have a completed application.
Well, they don't make a completeness determination. That's not required by ordinance. The first step is, as Ed suggested, the applicant meets with me. I do a site visit, collect information from the site visit that I show the board, with the main purpose of trying to prevent them feeling a need to go look at the site themselves and
Yeah.
delay the process.
Yeah.
The 1 extra month. And then I get input from all the department directors on the application. I share that with the board. I notify abutters, and I share with the board any information I get from abutters. But the difficult part I've seen for boards is when an application doesn't provide enough information for them to thoroughly review, to know whether or not they met the standard. And I've seen them struggle over the years. I've seen them struggle to try to find some way to say to the applicant, okay, we'll accept what you have, even though it may not really meet the test.
So, in those circumstances, obviously you don't want to have someone have to spend a lot of money on things, but you can certainly say to them, look, you need to go back and get some more information, or get some kind of, report done, or some survey if they need to show wetlands or something, and they need to get, something to meet the criteria. So you can certainly request some more information. I would think you would probably do that as opposed to just denying something for not having enough information. It's usually the way that a board would deal with it.
I can't recall you ever denying an application.
What's that?
Oh, you did. Yes, you denied Von Thibodeau's Corey application. That was a big one.
Yeah.
But
That was a long one, too.
yes,
Years.
that application review. They met 25 times on that application over a 3-year period.
Was that the
Yeah.
one that was going to be on 46?
I think so, wasn't it?
Was that appealed or?
It was appealed. It went to the Board of Appeals first. They agreed with most of the findings of the board. There were a couple that they didn't agree with, but they ended up supporting the decision of the board. And then they went to Superior Court. And the interesting thing I found about the court's decision, they supported the board's decision, but for the reasons they supported, and the reasons they supported were essentially the people in the neighborhood who said this is a horrible thing to happen in our neighborhood, and the people who lived on Route 46 who complained that the additional truck traffic would be a terrible impact to that road, even though DOT said this is a truck route. It's designed for truck traffic. But the court accepted the opinions of the local residents over the experts that the applicant provided.
Yes, and that is common in the quarrying kind of situations, in the mining and the gravel extraction, because typically the ordinances through the different towns have similar provisions, and they usually have one that the planning board have to weigh up the impact on the surrounding properties. Sometimes it's as vague as that. And so the court has held that a property owner can give testimony on their own value of their own property, and on obviously the impacts for them. So, and the court is not saying that they were right. Usually, they're saying there was enough evidence from the various. Often when you get a controversial thing, there'll be a lot of people that come. So they're all giving testimony. They're saying, I hear the banging all day, the gravel going through the sieves, and it's I don't work, I'm home all day, so even though they stop work at 5, I have to listen to it all day, and that everyone's going to come in, and the courts do say that a property owner is qualified to give that kind of testimony, obviously about their own impact, also about the value of their property. And when a court's reviewing the decision, they're not saying that you made the right decision. They're reviewing it to say, was there sufficient evidence presented to support that decision? And just because there was competing, because you're going to have the other experts, the applicant's going to bring in the real estate agents that say, it doesn't matter if it is a quarry, that's not going to make any difference to the property values. And they'll bring in another expert that says, well, we're going to put these noise things up and it's not going to be noisy. So just because there's competing evidence, as long as there's sufficient evidence from the property owners that will support it, the judge will say, yep, that was fine. So that's probably what they were doing.
Kind of discouraging, though, for an applicant who may spend tens of thousands of dollars
That's
on
very
studies.
Is it just a quarry? What about housing, or it's for sale now, but there was a few years ago, they wanted to, an old house up the street wanted to do assisted living
On Central Street.
and some of the abutters were, so if an abutter is opposed to any project, in my backyard type thing, how do we take that into account? If they meet all the ordinances and they meet all the standards, but the abutters are all opposed, do we weigh that at all?
If there's a provision that speaks to the abutters, like with in my experience, a lot of the mineral extraction or gravel extraction ordinances, specifically talk about the effect on the surrounding properties. But that's particular to sort of industrial types of operations and commercial types of operations. So if there's a specific standard that the applicant has to meet to say, well, there is no impact, but that's the only time you really need to consider what the neighbours are saying. Unless, if there's no particular provision or avenue, you could have someone come in and say, look, I don't want that there. It's right beside my, but hey, if they've met the criteria, so if there is something that speaks to the neighbours, you have to weigh up the evidence. Usually it says something like a negative, adversely affect the neighbour. And again, well, what does adversely affect mean? But again, it's common sense. It's something that's negative. But you have to weigh it with the type of application. If it's just an assisted living, well, what's the problem? It's not going to be noisy. You sort of go through the quality of life things. there's no, no evidence is going to affect your property values and other things. So, and then you have to, if it's in the town ordinance, obviously it should be granted. And you're right, like you can't just deny every application because one person comes in and says, well, I don't want it. It's a little different with those industrial ones because there's usually a provision right in there that speaks to the effect it's having on the properties around.
Medical issues. Somebody complains that they have a bad heart and they're concerned about the sounds from blasting giving them a heart attack, or they have some disorder that causes them problems, things like that. Can the board consider that?
Definitely, if it's, like I said, if it's a criteria with the blasting, if it's a criteria that they have to show to the board that it's not going to adversely affect the surrounding properties, and that's the language I'm using because I've done one recently with that language, then yes, if somebody comes in and says, I'm home all day and from, 8 in the morning to 5 at night, it feels like, somebody's blasting in my backyard. Yes, absolutely can take that into account.
We don't have anything, I don't think, in our ordinance that can be reviewed in that regard, though.
Yeah.
Well, there's noise control, there's dust control.
Right, so
things like
those kinds of things come.
The health impacts, that goes to the adverse impact, but it's not tangible. It's hard to evaluate that.
It's not tangible, so you need to have a sufficiency of the evidence. So one person is, may not be enough. But if you've got, 5 neighbours coming in and really laying out a lot of concerns and complaints, with the quality of their life, living next door to something that, and a lot of times too, it's how do they know if it's not already there is the problem. Like sometimes it's more to do with, say, an expansion. If it's already there and it's already, driving them crazy. But if it's going to be a new proposal, it's hard to quantify what the effects might be because nobody really, you don't have a benchmark for it. But it's the sufficiency of the evidence. If it's a criteria, and that's the other thing when it comes back to the whole sort of bias. If you have, 20 people coming in and spending 3 or 4 hours over several meetings just saying how awful this project's going to be because they don't agree with it and they don't want to live next to it. If it's not a criteria set out in the ordinance, you need to set that aside because if the applicants met the criteria, regardless of what the neighbours say, then you're supposed to grant it.
When the planning board reviewed the CMP power line expansion up in North Bucksport, we had neighbors come in and say that they felt that their health would be impacted by the electromagnetic fields from the power lines. They didn't provide any evidence, though, to support that. They would need to, wouldn't they?
They would, yeah. And again, it gets down to the sort of the criteria factors. I mean, if there's like a public health and safety criteria, then you can slip it under that.
Well, we do have a standard that addresses electromagnetic fields, and the objective is to ensure that any detrimental effects from electromagnetic fields are adequately mitigated.
Yeah.
But it doesn't, in the language of the standard, it doesn't talk about health impacts.
Right. Yeah.
It would have to, wouldn't it, in order to review that? That concern
there has to be something. It has to come under some criteria, either a health and safety or some other adverse effect on property owners, that sort of thing. And they need to have some tangible evidence on that. And it's similar with cell towers. Some people feel that cell towers are bad for their health, and siting it too close to a public place, a hospital or a school or something. But there's no studies to back that up. I've been involved.
There are as many that back it up as many that.
Well, exactly. You can get some obscure ones from Switzerland or something, but the local federal authorities say there's nothing wrong, and if you're complying with what they're saying, then it's hard for the planning board to accept that type of argument, I think. There has to be, sufficient evidence. But, if it's a standard and if it's a standard criteria in there and somebody does complain and you feel like it's a legitimate complaint, you can, even if somebody else wouldn't have accepted it, your decision will probably withstand a review as long as you have some evidence in there that's related to your decision. It doesn't matter if a reasonable mind would have made a different decision as long as there's enough evidence to support your decision. So those sort of the topics were more the things that I find boards struggle with, and I struggle with, is sticking to the freedom of access law, not having sidebar discussions. I mean, I get dragged into that too. At the end of a meeting, I'm trying to get out the door, and the board members are saying, "Oh, can you wait? I've got a question." And I'm like, "Yeah, I can't. The meeting's done. I can't answer it." And it's very tempting to sit down and have kind of a discussion with them to try and help them get over some of the procedural questions they have. But if you have any other specific questions about what you think you can and can't do?
This site visit thing is, I'm so new to this. This is my second board meeting.
Okay.
I don't know how many site visits these folks have done in the run of a year. In the last 2 years, I don't know how many.
One, I think.
Just one.
Very common.
I'm just intrigued what is someone's definition of site visit? Is it me riding out on my motorcycle and something that's come up in a meeting a couple of weeks ago and I'm driving by this place? So I pull over and I stop and I sit there and I stare for a couple of minutes. I mean, is that a site visit?
No.
By me? What if two of us that are on the board have to be out on a motorcycle ride and we pull over and do the same gaze? And there's two of us there gazing.
It would have
is that a site visit?
A site visit would have to be an actual time and date specified and advertised to the public. Right?
An official site visit is like
Another meeting.
It's like a meeting, so you publicly say.
And I understand that, but I'm saying is
but what you're getting at is more
The perception of it.
well, it's more violating.
someone perceived that I'm taking this upon myself
Right.
to go out and,
I have no issue with you going out and, if you're driving by, stopping and looking. If you're there with another board member,
Yeah.
I'd have more of an issue with that because you're going to start chatting about
Sure.
and that's what you're not allowed to do.
Yes. Okay.
But as far as being curious and driving by a place that has an application, I think that's fine. I think the best thing to do is just say in the public record, I drove by your house the other day, and by the way, I noticed that there was blah, 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 and you want to ask a question.
Yeah.
That's fine. That's fine. You don't want to happen, though, is to someone say, hey, I saw, both of them sitting outside my property having a good old chat about it.
Yeah, and I've seen them there 3 times in the last 2 weeks. And
Well, some of it we can't help. It's a small town.
right.
That is the issue. It is a small
Things
town.
that are-
No, true. I mean, that's what I said. It's easier to say what you're not to do than sometimes put it into
Yeah.
practice.
So
Not like you can avoid, you
Yeah, you
put a blinder on as you drive by.
It's the bias thing, is that between all of us, we probably know everyone in this town. Between all of us.
right.
Some of us have been here and worked jobs where we deal with people so we get to know more people, But amongst all of us, we must know just about everyone in this town.
But that's not enough to say you're biased or have a conflict.
Well,
I mean,
I agree, but in this day and age, what is not biased to me is horrendously bad by someone else's standard.
Right.
So it's
That's
just,
again, that can be a perception thing.
yeah, I think that's exactly what it is, a perception.
You have to weigh the perception with the reality, and it comes down to whether you or the other board members feel that you're biased. And it's not even so much being biased; it's whether you feel you can make a unbiased decision.
Yeah.
In the event someone was pursuing a project directly across the street from one of our houses, when would be the best time to disclose that? At the time that applicant wanted to pursue that at a specific meeting?
At the very first publicly held meeting
Yeah.
for that,
Yeah.
that would be the time when the
disclose
chair goes
that.
through and asks about any conflicts or bias. You could say, look, I live across the street.
Yeah.
You can either say, because of that, I'm going to recuse myself, and then just get up and walk away.
Okay.
Or you can say, I live across the street. I feel like I can, that's not going to impact my decision. I can make an unbiased decision. And then the chair can ask the applicant, do you have any concerns with that? And if they say no, then generally the board are going to be fine. If they say yes, I have real concerns because I've seen him out there, taking photographs of me or something, you could say, ask the board whether they think.
He'd be notified that it's in a butter before
Well,
he
yeah.
gets to the meeting.
Right.
He'd already,
And I think it's, personally, I would say if you're in a butter, you need to recuse yourself, regardless.
Really?
I do. That's my view.
Yeah.
Because you're directly, you're somewhat directly impacted on
Okay.
that.
All right.
I mean, if it's something like, what's something really innocuous that you have to come to the planning board for?
We don't have innocuous applications anymore.
No.
We got rid of all those.
Most of those would just come straight to you,
Yeah,
right?
we changed the ordinance so that
Yeah.
the board didn't have to deal with those very simple
Right.
projects. Yeah.
So generally I would say, because, if you're totally in favor of it, then someone's opposing it, they're going to say, well, he was biased because he's right,
He's in a butter.
he's right next door and he's, all in favor of this. He's probably best friends with him. He's a neighbor. That's no good. So, again, I think, if you're too closely related to the project, it's a judgment call.
Okay.
Yeah.
But back to Jay's question about doing site visits, should it be the expectation of the board to rely on the applicant to provide all the information they need to make a decision on the application? And if they can't get it, then they do a site visit as a group? I think I heard you say you didn't have a problem with a board member going to a site that was subject of an application, out of curiosity perhaps, but...
I don't think they should enter onto the property, but like if they're driving by,
But driving by for the purpose of collecting information?
well, just have a look. I mean, they want to get the lay of the land. Like, I'm a very visual
Yeah.
person. I look at a map and I'm...
But shouldn't they be expecting the applicant to give them that information? In photographs or videos? Or if they can't get it, they should go as a group?
Definitely should go as a group, but what I'm saying is if you do go by yourself and it's just you're not going on the property and you're just curious because you want to see the lay of the land, like that's something I would do because I don't understand maps.
Right, what-
Then I think you can just come and say, well, look, I drove by there the other day, and sometimes you see something from driving by that you want to ask a question on, and I think that's fine. If you're by yourself and you don't go on their property and you don't talk to them, and sometimes you're going to go by without even knowing. Like, you might know the property, and so then the applicant comes before you. And again, we're getting back to that personal knowledge. You may not have gone and done a site visit, but you may know the property well because you're a neighbor, maybe not a neighbor, but you've been by it. So again, you might say, well, I know your property. Your map doesn't show this, whatever, this wetland that I know is there or something, and you can ask questions about that.
This site visit, to get honest, I hate to beat this to death, but you've made your proposal to us, okay? And there's something in that site plan that I'm scratching my head about. Now, do I delay approving until my question is answered? Or do I just say to myself, I'll go check that at another time?
I
Just
think-
by that drive-by visit. I mean,
Yeah.
what?
I think
Where are you falling into
Right.
what's right and
First thing
what's
you should
wrong?
be doing is asking the applicant if you have any questions or any clarifications and giving them the opportunity to answer it either at the time of the meeting or to say, look, I can have my surveyor provide a better map of that, or I can bring in...
What if they either can't or won't?
If you give them the opportunity and they can't do it, either because they don't have the money to pay for a surveyor, or they just don't have the means or the desire to know what to do, and you've asked them several times, you could just deny. If they haven't proven it, I think
I mean, is it bad to deny until my question is answered? That's what I'm getting at.
if your question is related to one of the criteria
Yeah.
and they haven't, so therefore they haven't provided the evidence.
Until I get an answer that satisfies me, am I justified in saying
Well, it's not so much satisfying you,
I remember, don't prove.
it's satifying the criteria. So it's got to be...
His opinion of the criteria, like his opinion that it's met and all that, so,
Yeah.
yeah,
And I think you definitely, that's all the part of the discussion that you have. It's like, well, he's presented this evidence, but I feel like we've got these unanswered questions. I'd like more information.
Maybe as I go to more of these meetings, all this is going to
Yeah.
fall into place. But like I said, I'm really new with this,
Yeah.
and
And it happens.
I just want to make sure that I'm right.
It happens all the time.
Yeah.
You know, they'll start the discussion, the deliberations, and then they'll say, "Look, you know, if we got an aerial photograph, that would be really helpful." And they're like, "Okay, I'll get an aerial photograph, and you know, tell me what else you want, and I'll run off and get it, and we'll come back the next meeting." And then there's the aerial photographs, and that answers the question. I agree with Jeff. If they've done a proper application, they're really, 9 times out of 10, there's no need to do a site visit.
It may
Sometimes-
never ever come up the time that I'm on this board.
Yeah.
But my question is, if it does.
Sometimes it can be helpful depending on what the criteria is. Sometimes, if it is a question about neighboring properties, sometimes you want to get a visual of how far away are there's the houses, what kind of trees. I mean, even though it's on a map, sometimes you want to put yourself in those people's shoes. What is it, really like at that property line? If that's the main issue of like for a gravel pit or something, then maybe it's, worth doing a site visit if you're really struggling with that issue. But otherwise, there shouldn't be a huge need for it.
I think one of the hardest things we have to deal with sometimes is an applicant that's almost there. And they spend quite a lot of money getting there, but we request one more thing, and they don't do it. And we had one out on Town Farm Road, I'm thinking of.
There's a subdivision application, yeah.
We just needed some runoff, I think is what we were looking for.
I can't recall now what it was.
I think that's what we were looking for, just a little, it was just a little bit more information, and they never came back. And that was after they were very nearly there. They had a good plan, and they went and bought another piece of land to get a right-of-way in because they couldn't get the right-of-way where they wanted to from the Henderson property. So they put quite a lot of effort into it, but it just wasn't quite there to receive approval. You remember it probably, yeah.
No, I don't remember going through that. That was probably before.
Maybe you weren't on the board. I thought you were. But
No.
But
I started during the
that's one of those things you want to coach them a little bit, but
Yes, yeah. No, I mean, boards are usually very flexible and they're very lenient with giving people as much time as they need to satisfy the requirements. And generally, in my experience, with the exception of a couple of cases, they're pretty, if you have to meet a requirement like drainage runoff, they're going to sort of ask for something that's, not going to be like a $10,000 report. It's going to be just something fairly easy for them to obtain. But the thing to remember, the burden of proof is on the applicant. So if they haven't met the criteria and you're not quite satisfied, then it is up to them to get that evidence. And if they just don't, maybe they just had a change of heart. Maybe they just did a 180 and decided they didn't want that after all. I mean, can't read too much into that, I guess.
I'm not quite sure if they ever did anything. Did they sell the property?
No.
I don't know what's ever become. I don't even think they're in town anymore, are they? They're the ones that own
Yeah, they're still there.
Spectacular Events, the father did.
He's building a new house on Town Farm Road.
Oh, yeah.
One of the things the board has struggled with over the years is the lack of easy-to-understand language in the land use ordinance. The standards that they used to have were very vague and
Yes. Yep.
to misunderstand, and they struggled a lot with that. And as a result of that, their application reviews tended to be a bit prolonged because they're trying to figure out what they were supposed
What
to
does
do.
it mean? Yeah. Yeah.
So, and that has an impact on the public image of the board.
Yeah.
And they were getting a lot of criticism from business owners and developers about how long it used to take to get through the board. It was torturous, in some cases. But they've come a long way. Now, our ordinance also has been improved, I think, with more details,
Right.
more clarity.
I
That
think,
makes their
yeah.
job a lot easier now.
I was going to say sometimes that's an indication that the ordinance needs reviewing and updating. And that gets into the whole other issue that's not in your jurisdiction to decide. But a lot of times, some of the standards can be a little vague, and you wonder what they mean, and there's no precision. And it's not up to the Board of Appeals either. That they're what you call constitutional issues, because if the language in your ordinance that says you have to meet these criteria, if the criteria is too vague, how does anyone know what they're supposed to meet? And that's a constitutional issue. And so that usually ends up being resolved by the Superior Court or the Law Court, who will either say, no, it's not vague, you can, interpret it this way, or they'll say yes. I mean, if something says it's not going to, impact the view of the neighbourhood or something, if it's, and you're like, what does that mean? And how am I supposed to show that? So some of the, as time goes on, the provisions that cause problems can get updated, be more precise, I think. Sometimes it was when people were drafting ordinances, they would copy the ordinance from the town over, and it might not have been a good one. So there'd be a lot of old language saying, just very unspecific criteria, which leaves it too subjective. And that means that an applicant doesn't know from, what they're supposed to approve. And the board might, approve one but not the other, even though they're both the same.
It kind of reminds me, of the reading. I mean, what we do now is so much easier, and you guys don't even realize that, but we used to sit here for hours reading the criteria and the findings, remember?
Yeah, you're one of the few board members left from that time period. Yeah.
I'd forgotten all.
Yeah.
Well, you brought back an image.
They've had the public here actually criticizing them for their failure to do timely reviews and to make it very difficult for new businesses wanting to come into town.
Right.
And I think it's sensitized the board to a certain extent, and that they want to be able to say yes, and they understand that the yes has to be supported by the facts.
Yeah, because you're going to otherwise be criticized for just rubber stamping everything.
Mm-hmm.
But again, I think if there's certain provisions that you're stumbling over again and again, then you need to form a committee to look at reviewing those. With Jeff's help to make them easier to interpret or easier to identify. But once you've been to 10 more meetings,
I'll be a veteran, eh? Sure.
I'll say Jay has spent many of his years stuck in neutral, working in law enforcement. So he is in search for one gear direction of the other. He is constantly in fact mode, as am I.
Yeah.
If a board's decision is appealed, what role does the board play in that appeal process?
That will depend on, a lot of times it will depend on what the issue is, like what's being appealed. Like a lot of times the municipal officers, whether they're selectmen or a town council, will just say, well, what do we don't always really care in the outcome so much. We're not going to pay to have someone go and defend the board's decision. It's usually, up to the applicant to do that. But so for example, it goes to the Board of Appeals. There's not too many situations where you'll have the planning board actively involved in that appeal process. Occasionally, it does happen if it's a controversial issue, and the planning board felt like they really have to be defended in their decision and their review process. The municipal officers might agree to have an attorney representing the planning board at the hearing, and also have an attorney representing the Board of Appeals. That doesn't happen very often. So most of the time, if something's appealed to the Board of Appeals, the planning board doesn't usually take much of a role in that. Usually, I think here it's usually, unless it's a variance, it's usually just an appellate review. So they're just looking at what the planning board did, so there's no more evidence coming in. Is that correct?
Right. So the reason I'm asking that is because we have had appeals, and I've been asked by board members if they should go to the hearing, to state whatever or answer questions, and I'm not sure how to answer that question. Really, the Board of Appeals is reviewing the record of the board, right?
They're reviewing the record of the board, and I think that I think that they definitely, if they're gonna, I think they need to decide as a board whether they nominate one person to be a spokesperson, and they can certainly go and say, look, if you have any questions, I'm here to answer them. And you can also advocate. You can go and advocate for your decision and just say, most of the time boards don't, but you can. And you can go and say, look, the reasons are stated there in the record, and you can talk to those. You can't give new evidence, obviously, but you can advocate for the reason why you made it. Most of the time the boards don't do that. But you can. And you can certainly go and sit in the public and listen and watch. You can do that. The other way around, though, like the Board of Appeals, people should not be coming to the planning board meetings because they might end up having to listen to them on appeal, so they shouldn't really be partaking or listening in those.
So another question kind of related to this is the planning board is the municipal reviewing authority for drafting changes to the zoning ordinance of the town, and they do that, and then they forward their recommendations to the town council. On occasion, the town council has rejected a change brought forward from the planning board. Does the planning board have any recourse if they believe that the council's decision was not appropriate?
Well, yes, they can just ignore it because it is, the attorney doesn't, or the council doesn't have the authority to make the decision, but they're their counsel, and they're usually giving a reason why it's been rejected. Either it's too vague, it's too imprecise. There might be already a case decided that's rejected the language. Hopefully they're giving a reason for rejecting it.
But
So we can ignore the town council?
Oh, sorry. I'm thinking of it, not the town. I'm thinking like a attorney council. You're talking about the town council.
town council, yes.
Sorry. I'm thinking you sent it to your town attorney, who's also sometimes called the council.
No, the town council is responsible for approving any ordinances.
Right, sorry. Okay. So I take all of that back then. So.
I like your answer, though.
I'm going to get you all into trouble. Yeah. No, sorry. No. So they're the other ones that have to, authorize it under your statute, under your ordinance. Yeah. Do they give reasons why they reject it?
Well, they'll talk about it. Sometimes they explain why, and sometimes they don't. But it's not often that they don't accept. We just actually made an amendment to our charter that required all amendments made to our zoning ordinance from the planning board to be directly reviewed by the town council. In the past, they have been referred to the ordinance committee, which is a group of 2 or 3 council members that sometimes they will pass through the changes without any concerns, but other times they will make some changes. And so the ordinance that ends up at the council can be a lot different than what the planning board recommended.
Yeah. So, the town council takes over from the smaller towns that have the selectmen, and then the legislative body is the townspeople at town's meeting. So in those smaller towns, you put it on the town warrant, and they're the ones that can, the planning board could work for 3 years and craft this beautiful ordinance, and then you get to the legislative body, which in this case is the town council. And so, yes, they're the ones that are stepping in the shoes of the townsfolk and deciding whether or not to accept it or not. I mean, I guess if some people felt strongly in the community, there must be a referendum process.
But otherwise, the council's decision is final.
Well, I'll have to read the actual language in there, but I suspect, yes, it's because it's similar to, because they're the legislative body of the town. So if they reject it, it's like a town meeting. If it gets rejected, it's rejected.
Yeah. They hold a public hearing. Well, actually, I'll take that back. They don't. We changed that in the charter too now. This public hearing is optional. The planning board holds a public hearing because of the law requiring it. The town council now does not hold public hearings unless they feel it's appropriate to do so.
Right. Yeah.
By charter. That was a charter change. Before that, they had to hold a public hearing for every ordinance change.
Yeah.
So there were 2 public hearings for every amendment to the zoning ordinance.
Right.
kind of redundant, so.
I mean, it would be helpful to know why they rejected it, obviously, whether they're just rejecting it outright as a bad idea or just because of some language they don't like. I mean, it's... makes it hard if you're trying to draft changes. But yes, you can't just... If they've rejected it, you can't implement it.
But could the planning board go back to the council and ask them to reconsider?
Absolutely. And you can go back asking what, for some reasons and some feedback. You might not get it, but... and you can keep resubmitting different versions.
It doesn't happen very often where they're not happy with what you're bringing forward.
Well, occasionally we get short-circuited, though. And we don't even get a chance to really evaluate an ordinance, if you will, because the council already tells us, don't bother to send it, we're not going to pass it. I'm thinking of the marijuana.
Yeah, that was a case where the council actually requested you to draft an ordinance to ban non-medical marijuana retail sales in Bucksport. They asked you to do that, and you agreed to do it. I'm not sure if you were all in favor of doing that, but you did agree.
Well, I thought it was silly because I think any crop is a crop. I think anything has potential income. I don't see any difference from raising potatoes or anything else as long as it's controlled.
Yeah.
And I just think my own personal feeling was we were short-sighted in that. And the council was short-sighted because
But you still
of
held,
the stigma
you
of the
still
drug.
hold a public hearing on that, right?
We did.
Yeah.
We had two people show up that were against it. One was the nurse.
Yeah.
Town nurse, and one was, I don't remember who the other, well, he may have been policeman. I'm not sure.
And I can tell you right now that was probably because of the problems associated with it.
Well, I'm sure it is.
The residual effects from that type of thing go far beyond.
People have no idea.
It goes far
Far-reaching
beyond
effects.
the actual substance or the actual crop that you're describing. The things that are associated with it cause a lot of problems. So.
Yeah, but at the time, though, I remember thinking that people were thinking that and saying that.
Yeah,
But you go down the street here a mile, you're in another town.
correct.
And to think that problem, those ill effects are going to stop at the town line
Exactly.
Agreed.
is kind of ridiculous.
Correct. Yeah,
Yeah.
well, I agree with that also.
It's not. This isn't the Wizard of Oz here.
Right.
It's like,
So if the planning board had decided to refuse to comply with the council's orders to draft an ordinance with that language in it that they wanted, as a municipal reviewing authority, that's this board's duty to comply with that law requirement, does that mean that the town council can't draft their own changes to our zoning ordinance? That has to be done by the planning board?
No, I don't think the planning board are the only ones necessarily that could draft the ordinance, especially if they refuse to do so. But, like private citizens can draft an ordinance and by petition have that submitted as well.
Yeah.
If they get enough signatures on there, you would then have to hold a public hearing and then send it up to the town council to obviously probably reject, but they still have that process of doing that. That's a good question. I don't know the definitive answer to that. I think they would maybe organize another subcommittee or something to do
And for
that.
years, that's the way it was done. The planning board was never involved in our zoning ordinance for years until I finally convinced the town manager that the law says you really need to involve these people. And he agreed eventually, and now every amendment to our land use ordinance comes through this board.
But it doesn't mean you can't farm it out to somebody else to draft. The actual drafting.
Yeah.
I mean, you can have a subcommittee made up of other talented people in the town, and then it can come back to the planning board to refine or change or Yeah, that I can look into that more. I wouldn't know, I don't know the answer to what would happen if the planning board refused to do something, to draft an ordinance.
Would the council remove all of us from office?
No, they can't.
They put us here, don't they?
Yeah.
Would they take us out?
They can only remove you. It's a section if it's.
For derelict of duty, like not acting upon their, I don't know.
I don't have it in front of me,
Yeah.
but it's like 2016 or something in the
Yeah.
municipal statute, and it has to be for something decently egregious, not just because they
Not
didn't,
following orders of a superior or
didn't
something.
like
I don't
your-
know. It's-
they can't remove you because they don't like your decisions or opinions.
Sure.
But maybe refusing to do something you're supposed to do would be enough to do that. But I can't imagine that would be the way it would play out. There'd be some other.
Well, one would think that we could sit down and could come to an agreement or an understanding on something. Because there's just not enough of that in this day and age, apparently. I know. Listen, I'm not from here, okay? I've only lived here for 35 years. I'm not from here. So you're going to forgive me.
Geez, I might have you beat. I think I've been here about,
69.
huh?
I'm going to be 69.
Well, actually, my sister moved here in 1964, so I've been kind of associated. But I haven't lived here that long, 30 years, I guess.
I was away for 5. Oh, man.
Seen a few changes. I think.
Is there anything else?
I mean, I could talk more, but I think they're the ones that I feel cause the most issues. Do you have any other questions, Jeff? Because you've been kind of managing the boards for many, many years.
Nothing comes to mind.
I see. So all the board members have manuals, so you're given, they like the MMA manuals that you have?
Yeah, I used to give out paper copies, but now I do a digital copy. And
Yeah.
that was updated a couple of years ago, I think.
Yeah.
So I think you found it
My
helpful.
manual is now 474 pages long.
I've got a paper copy of it here. It is.
Yeah.
This is from 2011, so there's an awful lot of information.
And I have read it. It is voluminous.
Yeah.
No offense. Right at the beginning, I could tell after the first 10 pages it was written by 2 attorneys, okay? I'm sorry, I've been in law enforcement for over 30 years.
Yeah.
But,
Yeah.
but it's a nice manual. It
Yeah.
really is. I don't know if you had anything to do with that, but whoever did, I mean, there's a lot of stuff in there.
No,
There's a
they're
whole lot
great
of stuff.
manuals, and they're a great reference, and
Yeah.
you're not obviously not expected to know everything that's in it all the time, but that
Well,
would
it's
be
good for-
my first recommendation is to, if you're having a question about if someone has standing or jurisdiction and those kinds of things, look it up in your manual and read through it, because it's going to help you out.
I had no idea the scope of subjects that could come before this board.
Yeah.
I mean, I had no idea until I went through that manual, Jeff. I mean, it's just, I had no idea.
Well, that's a good thing to talk about. What kind of applications you will be getting. You get land use applications for site plan reviews. You've done a couple recently, 2 projects out in the industrial park that were new developments. You'll also get subdivision applications, and there'll be one of those coming up shortly for you. And you might get a flood permit application. Most of those are through my office, but there is one type of flood permit. I can't think what it is off the top of my head, but I think it does require planning board review. And that's it. Those are the only ordinances that might involve you. The land use ordinance is the one that obviously you deal with most of the time.
So apart from that quarry, there's not a lot of gravel pits in town.
Oh, we have a lot of gravel pits, but nothing
they're
that's...
existing.
What's that?
They're all existing.
yeah.
Yeah.
We haven't had a controversial application for quite some time. I think the last one was the Von Thibodeau.
Well,
Yeah.
there was
Okay.
one that he just kind of stormed out of the meeting and never came back. They wanted to do the septic dewatering over on 46 somewhere.
Oh.
I don't know his name, but
Yeah, well, that was a case where there was an existing development that had been approved by the planning board. You approved a site plan that was very specific about what was being approved.
we made some changes.
And he decided that he wanted to expand the development by bringing gravel in to fill, to create more usable space.
Yeah, that's right.
And he was informed that he needed to come back to the planning board to change the approval of his site plan, to amend it. And he was not too keen on doing that, but
Sold it instead, didn't he?
yes, it's in
Well,
ownership now.
So he
Sold it instead.
He came in to tell us that he wasn't going to come in. And so it was,
But I think he was hoping that you would tell him that he didn't need your
Right,
approval, but you didn't say that.
and you know, somebody mentioned, if somebody comes in with an application that is 50% or 60% complete, I don't lose any sleep. If they want something, they need to do what they need to do to get it done. You know, we don't owe it to them, they owe it to themselves, I think. And if they come in with it, we've had several at the gas station, the church, and then the mussel. I wasn't here for the lobster one, but those were great. I mean, they had everything right there in the
Oh,
package.
some have been damn near perfect, and that's true, but there's been a lot of money and engineering and science
Right.
behind a lot of them.
But if they're
very well
concerned, if
paved.
they're serious about a project and they're gonna do it completely, they come in with a great plan.
Yeah. But
And-
the smaller business owner, 5 or 6 employees or something, you know, he may not have the expertise or know exactly what he needs or where to get it. You know, it is, to get to here is not that easy. I've been doing civil engineering for 50 years now, and I'm not uncomfortable with it, but the average person out there would be. So it's a learning curve. Some applicants don't have to, but they just pay their way and get what they
But I
need for
mean, you could get CES or one of those local folks, they'll do something doesn't
Some of them are
cost you,
very good.
doesn't cost you an arm and a leg. I mean,
Oh, yeah.
you know, but
Yeah, I mean, generally, if they don't have a surveyor or an engineer or someone on board, it can be difficult to know what, extract the information. But if they do, those people they know exactly what the boards are looking for, and they'll prepare it.
Too long. Thank you.
Yes,
thank you very much.
Thank you.
Thank you.
Now, I'm curious now. I'm going to look into that issue. What happens if the town reject your ordinances? I suspect you're stuck with that decision.
Anything else?
Time for dinner.
Okay.
I just wanted to, we have a discussion on the agenda too, right? Thank you.
Thank you.
Thank you.
Thank you.
We just passed it over there. Sorry.
As I mentioned earlier, there'll be a subdivision application coming to you possibly at your next meeting. It's from AIM property up there. They've done this one split of that property that they conveyed to Bucksport Generation LLC. It was a power plant area. And the remaining portion of the lot was retained by Bucksport Mills LLC. These are subsidiaries of AIM Corporation. They're going to convey a large chunk of that remaining parcel to Whole Oceans, but keep still a section by Bucksport Mills LLC. So the end result is you'll have 3 lots created within a 5-year period. That's a subdivision by definition, and it requires your approval. So that should be coming.
Didn't we see some news about an ethanol processing plant, wood alcohol processing?
I haven't seen that.
It's been in the newspaper.
What, in the local newspaper?
Yeah.
I guess I haven't read that yet. Is that this last week's paper?
No, a couple weeks ago.
I missed that.
Dawn fantasizing.
Huh?
Dawn fantasizing.
Maybe you dreaming about reading it?
I couldn't see that.
The factual
the applicant
enterprise?
was
But related to that,
solvent, monetarily solvent.
related to that division, when you see the plans, the lots that are created have essentially 100% coverage of impervious surfaces. This is the mill site. It's all concrete and pavement and buildings. So, but when you create a lot that has 100% coverage, that's a nonconformity because our ordinance only limits 80% lot coverage. You have to have 20% vegetation. in
Well,
your
that
lot.
mill site never been 100% covered at any time.
It's never been, no, it's not even close, not even close, because, you're talking about a 112-acre lot, and I'll look it up, and it's at the lower end primarily, so there's a big chunk of vegetated lot that, the lot as it is now is conforming. It's conforming to coverage, it's conforming to shorefront requirements, it's conforming to street frontage requirements, it's conforming to building height requirements. But when you split the lot now into smaller lots, then you have to look at the standards, how the standards apply. And one of those standards is lot coverage. Now, because of that issue, I'm going to suggest that we, and I've already asked this question to the DEP, is if they would consider allowing us to increase the lot coverage to 100%, so we don't have to worry about that, and to remove the minimum shore frontage requirement, so we don't have to worry about that when they want to split this property up into smaller lots. I sent that email out today. I haven't got a response yet, but you may recall that they agreed to do that in this district here. They allowed us to eliminate minimum shorefront requirements. They allowed us to have 100% lot coverage.
Oh, okay.
And they reduced the lot size to 1,000 square feet in this district or in here now.
So it's been done in past practice in town?
Just this side of the Main Street.
Okay.
We explained to DEP, we thoroughly justified the need for us to do that,
Yeah.
because we were finding that people wanted to do things with their properties on Main Street and couldn't because they couldn't meet the dimensional requirements.
Right.
So that's been changed. And I'm hoping they'll have the same opinion about the issues with dividing up the mill property into smaller lots, primarily because of the impervious surface issue of exceeding 80%.
On the backside of that, if there was more of an issue, couldn't the property, the portion that AIM intends to keep, couldn't they restructure that property a little bit to plant some trees and some grass to obtain that 80%?
Well, it's covered primarily by concrete slabs, which they want to keep for reuse. All the slabs where the mill buildings were. And, of course, there's driveways to asphalt.
No, I don't look at those slabs as being permanent for any buyer.
Well, that's a decision
No,
that will have to be
if he
made.
wants to leave it there, and a buyer comes in and buys it, he doesn't have to keep them by any means.
Nobody's saying that, Ed.
No.
Nobody's saying that.
And you must be asking, 100% lot coverage must be applying to these power plants. That's the only lot that is anywhere near 100%.
Well, the other one that would be if the split that Ames proposing for the piece to be kept by Bucksport Mills after they convey to Whole
Yeah.
Ocean, that piece would be 100% lot coverage as well, too. It's comprised
I have to
of...
see where those lines
It's
are.
it's comprised of the remaining buildings and pavement. There's no vegetation. It's just no vegetation. Certainly not 20% vegetation. So by changing our ordinance to deal with that, we don't have to worry about those questions and whether they're creating a conforming lot or a non-conforming lot. So when I hear back from DEP, hopefully they'll consider doing this, and I'll draft some changes and bring those to you, possibly at the next meeting.
Excellent.
So railroad still owns their property, which is basically all the frontage. And then, of course, the highway is beyond
Yeah.
that.
Street frontage is another one, too, that I'm going to suggest we eliminate. There's no need to have a minimum street frontage for that property. It's 100 feet right now, per principal structure. I did some rough calculations on the whole Oceans project. If I'm anywhere accurate, they'll only have about 10% lot coverage of their project. So they're purchasing almost 92 acres. And if my estimations on the size of the building and parking lot is accurate, maybe about 10% of that will be covered.
Isn't there plot right about where the wood operation is going on right now?
Yep.
I know it's north of the main entrance and south of the north gate that this Whole Foods plot is going to be. So is it more or less centered on where the wood operation is going on right now?
Pretty close to it, yeah.
That still leaves
That's
enough big
that's
plot
up
of
in
land.
that flat area where they processed the wood the last few years, not so much down in the old wood yard. But up,
Yeah, where they're doing it now.
yeah, there was some new
They got all
buildings.
those logs built up.
There was some new buildings put
Yeah.
up back.
Yeah, where about 10 years ago,
Scale. Yeah.
Yep.
about 15 years ago, they built a drum debarking facility where they're now having
Yeah.
mobile debarking.
Yeah.
Yeah, how many million one that they tore down?
Yeah.
Yeah, okay.
Yeah, right about there.
Another thing I wanted to give you an update on, at your last meeting, I asked you to review the proposed changes to the subdivision ordinance. You weren't here, Brian, for that, but the proposed changes were to updating the phosphorus manual label and to allow, in some cases, a gravel road to be used for a subdivision. That went to the ordinance committee on the 10th, and they weren't happy with that change. But surprisingly, they wanted to change the language so that any subdivision could be provided with a gravel road. Right now, the ordinance says any subdivision must have a paved road.
So ain't that way
So
in
they're
Ellsworth?
suggesting we do a 180 and allow gravel roads for subdivisions.
So they weren't happy with, because we didn't go and make,
They go far enough, yeah.
we didn't go far enough.
Was it that they had to have a paved road, or that they had to have access by paved road?
No, a subdivision that includes a road,
Right.
that road needs to be built to town standards, which includes pavement.
Okay. All right. That road.
Royal Ridge is
itself.
an example of that.
Right. Okay. Right.
But the language I had drafted would allow, in one particular case, a property owner out on Burr Lake, he's accessed from Strickland Ridge Road onto a private road he built that goes down to the shore. He wanted to put a subdivision down there. The ordinance would require him to pave that road. And I'm not even sure that he might have to pave the portion of Strickland Ridge Road that gets to his road, but at the very least, he'd have to pave that road. And he argued that it didn't make sense that, you're going down a gravel road on Strickland Ridge Road, why do I have to pave my road?
Right.
So the language I drafted would allow him to do a subdivision without having to pave his road. But as I said, for some reason, the ordinance committee felt that we should be a bit more liberal than that and say that anybody who wants to build a road for a subdivision they're proposing does not need, they have to build the road to town standards, but they're not required to pave it unless they want the town to take it.
That makes sense.
Didn't you, Ed, said that there's less phosphorus runoff on a dirt road than there is a paved road? Did you say that?
No.
Okay.
No, because
I don't think that's true.
And I have no idea, so I'm asking.
I think you get more phosphorus on
Yeah.
the paved road. But I'm not 100% sure on that.
So what was the intent of that, to do away with every dirt road? Boy, I can remember in the early 80s when I first came to work in Bucksport, man, we had a bunch of dirt roads.
Oh, yeah.
I mean, we had a lot of dirt roads.
There isn't another subdivision I can think of in town that is on a private road. Royal Ridge is the only one I can think of. That was built for that subdivision. Every other subdivision I can think of is on a town road.
Well, Royal Ridge is on Central Street, so.
Well, I know, but it was a road built for a subdivision.
Yeah.
That,
But there's a trail pack just about that. That's not paved.
I don't know if that went through subdivision review. That's probably predates subdivision. Harriman Cove, I'm not sure if that went through subdivision review.
I think that's been here since God invented mobile homes.
Yeah.
That part.
But if we get the application,
Code was bringing the septic system up to
if we get the application for Haw subdivision now, you're going to be looking at a paved road there, unless they change the ordinance before you get the application.
No. It only has to be paved if it's going to be taken over by the town. You just said it, so forget it.
That's the change.
That's the change. Yeah.
Right now, the ordinance says that the roads have to be built to town standards, and you can't waive asphalt. That's what the ordinance says now.
That's not what you just said.
Well, if there's a change.
I'm just saying that if the ordinance is changed, the changes that the ordinance committee wants to make, are adopted by the town code, then you're only required to build your road to town standards as far as gravel goes, and pave it if you want the town to take it. If you don't want the town to take it,
That's an easy
if
fix.
you don't want the town to take it, it does not need to be paved, but still needs to be built to town standards. That's what they asked for.
But it's only proposed.
That's the proposal.
Yeah.
It's not fact yet.
Yeah. So,
Didn't all work out.
I'm down.
but
We actually met, the ordinance committee's meeting again at 5 on the 31st, I think, is the next council meeting. And we met at 5 on the 10th. And we went to about 6:45. They also reviewed the proposed food sovereignty ordinance, a change to council rules. There's a new committee structure that's being proposed. They've whittled down from, I think, 9 or 10 committees down to 4. And they reviewed a proposed update to property maintenance standards. There were a few people who attended that meeting and who expressed concerns about some of the changes, but one of the biggest change for that they were supportive of is safety inspections for multifamily buildings. The proposal is to require full building inspection of multifamily buildings and commercial buildings with at least 2 dwelling units in them once every 5 years.
Wow, that's great.
yeah.
That would be done by both the code enforcement office and the fire department. I asked the question, it was my proposal 5 years, but after I'd written that, I did a count of how many buildings that would be involved, and there are actually 64 properties that would be inspected with about 400 units total.
Yeah, that's a lot.
Every 5 years.
That averages about once a month, one per month over a 5-year period to get them all done in a 5-year cycle.
Yeah.
And I asked the committee if they thought that was, if they thought maybe we should go a bit longer than that, but they did not want to go longer. They stuck for 5 years.
Oh, I agree.
So we're going to be busy.
Probably have to get an assistant.
Yeah.
I retire again.
Another proposed standard that surprisingly they didn't feel comfortable was a proposal that storm damaged trees, diseased or dead trees that pose a public safety hazard must be removed to the extent needed to eliminate the hazard. And they weren't comfortable with that, so they asked that to be taken out. I pointed out that we have that language now for trees in a shoreline zone. If you have a tree that fits that category in a shoreline zone, the language is in our ordinance now that we can deal with that. And they said, why not make it townwide? But they didn't want to go that far. So that was the only other substantial change to the property maintenance standards ordinance that they did not want to keep in there. Other changes were very minor, just adding clarity, reorganization to make the ordinance read a little bit better. So that's going to be, the changes they asked me to make will be looked at again at the next ordinance committee meeting. I think it's the 31st at 5 o'clock. And then another chapter 12 is being amended primarily to deal with the parking requirements in this parking lot out here. You may know that the Chamber building is being sold, and as part of the sale, the new owner is being given 2 parking spaces in this parking lot.
One.
Yeah,
But anyway,
in case they put a tenant in there, or for their own use too, they could park. But if they put an apartment in the building, then the tenants would need overnight parking. The problem is, this parking lot does not allow overnight parking. So the change to Chapter 12 will change, it'll change that. So that's parking, overnight parking will be allowed in designated spaces, and there'll be 2 spaces here that'll be designated for the apartment, and also the spaces down by the motel, which have often been used by motel customers to park
Quite
overnight.
often.
Yeah. Will be clearly identified that that's okay, or right now it's not technically okay, but there's no signage down there, I don't think, that says you can't park, but
Is that a trade-off, keep the gate open?
no.
You're referring to the either 3 or 4 right
Did we
here
ever take that
alongside
eminent domain?
the hotel.
Yeah.
They're
I
trying
don't
to
think
take that
there's any
eminent
signs.
domain.
And then the other change to Chapter 12 would be just to correct a conflict between the signs that are out here. The signs out here say there's no roller skates,
Bicycles, scooters. I walk by it almost every day. Yeah,
but scooters is not in Chapter 12. So it's on a sign that's being prohibited, but it should also
Is that
say
a
that.
motorized scooter or one of those scooters
Razor
that
type
you...
things.
what about a motorized wheelchair? Good Lord, you ain't gonna get that picky, are you?
No, that's not prohibited.
But is that just the foot scooter, you know, the two-wheel thing that kids always...
Segway?
No, it's like they call them razors. The two wheels inline with a little board between them.
We used to call them scooters, didn't we?
Yeah, I think the
One point in time, they had a
popular
handle,
brand name
T-handle.
is Razor.
Something did.
You could pedal with your...
But that's not what you're talking about. You're talking motorized ones.
No.
Oh, you're talking the toys. Well, kind of toy.
You can't ride a bicycle, you can't use roller skates or inline skates, although I don't know why you'd want to on that kind of a hard surface to
Boy, that would be.
skate on.
Some of the bricks are getting a little
Yeah,
uneven there.
skill.
Don't we have a local officer that rides a bicycle up and down there?
We do.
Public
There's-
safety.
there's them.
Huh? He's exempt?
Things like, yeah, public safety is exempt from things like that.
Yeah.
It says no bicycles. That's not what they really mean. It's what it means, but it's not what it really means.
So anyway, I think that's all I have for discussion.
Okay. Anybody else? Okay,
Motion to adjourn?
okay.
Second?
All in favor?